Imagine for a second that you are walking home late at night. Just, minding your own business.
Right, a totally normal scenario.
Exactly. And you turn a corner and you witness a severe emergency. Like someone is unconscious on the ground, they're bleeding, and clearly in desperate need of immediate medical attention.
Oh, wow.
Yeah. And you have a smartphone right there in your pocket. There is absolutely no threat to your own personal safety.
You're totally safe.
Totally safe. You could easily dial for an ambulance in, 5 seconds? But instead, you make a conscious decision to just keep walking. You do absolutely nothing to help.
Which is just a horrific thought.
It is, but here is the shocking reality we are exploring today. In the UK right now, doing nothing in that scenario is perfectly legal.
It's a profoundly jarring concept for most people to process, to be honest.
It really is.
Because it completely contradicts the basic social contract, right? And every natural human instinct we have to help a fellow person in distress. But when you look strictly at the jurisprudence, that calculated inaction, that deliberate choice to simply walk away, it does not cross the threshold into criminal behavior under current British common law.
Well, welcome to the deep dive. Today, we are exploring a monumental proposed shift in British law known as Danielle's Law.
Right.
And this proposal, it forces this massive ethical collision between the deeply held tradition of individual freedom and the absolute sanctity of human life.
That's a huge clash.
It really is. So to navigate this, we are pulling from a stack of sources and analysis compiled by Edwin Duggan.
A really fascinating figure.
Oh, definitely. He is
Yeah.
a prominent human rights advocate, the author of Breaking the Chain, and a fierce anti-knife crime campaigner based in North Wales. We are using his detailed breakdown to explore not just the legislation itself, but the profound philosophical roadblocks it is currently facing.
Yeah, and if we connect this to the bigger picture, this goes far beyond tweaking a statute or just adding a new penal clause to a bill.
Right.
This is about redefining the foundational mechanics of what citizens owe to one another in a modern society. I mean, it is a debate over whether the state has the legal and moral authority to criminalize a lack of basic human compassion.
Which is heavy. And that legal gap, the space where a lack of compassion is entirely legal, it didn't just expose some theoretical quirk in the law. It allowed a real-world tragedy to unfold.
It did.
To understand the momentum behind Danielle's Law, we have to look at the 2023 death of 33-year-old Danielle Haggerty.
Yeah, her death is the absolute catalyst for this entire legislative movement.
It's just awful.
It is. She died following a violent domestic incident where she sustained just catastrophic injuries.
And the heartbreaking detail here is the timeline, isn't it?
Yes.
Because she was left unconscious and unaided for an extended period. The subsequent investigations revealed there were clear, actionable opportunities for someone to intervene. And we aren't talking about performing complex triage here. We are talking about making a simple phone call to emergency services.
Just dialing 999.
Right. And that call was never made. Her family has forcefully argued that if a legal duty to assist had existed, Danielle might still be alive today.
And, exploring that timeline reveals the specific mechanism of how domestic abuse perpetrators manipulate the current legal framework.
Right. How so?
Well, in many of these severe domestic violence situations, the abuse doesn't actually end when the physical violence stops.
Wow. Okay.
The sequence follows a very specific, grim pattern. The violence occurs, the victim is left in grave peril, and then the perpetrator intentionally runs out the clock.
They just wait.
They deliberately delay calling for help.
Okay, let's unpack this. Wait, so if someone deliberately leaves an injured person to suffer just to protect themselves, the law currently just lets them off the hook for the abandonment part.
Functionally, yes.
That is wild.
I know. Perpetrators understand that dialing 999 means inviting the police and paramedics into their home. It means immediate scrutiny, potential arrest, and a total loss of control over the narrative.
So they prioritize self-preservation.
Exactly. They prioritize self-preservation over the victim's life. They wait to see if the victim will wake up, or they spend hours cleaning the scene to hide evidence.
Just buying time.
Right. And in cases of severe head trauma or internal bleeding, medical professionals talk about the golden hour.
That critical window, right?
Exactly. That critical window where intervention can actually save a life. By intentionally delaying, the abuser ensures that window closes.
But surely, the law can prosecute them for death itself if they cause the initial injury, right?
Oh, they can absolutely be charged for the assault. Or even manslaughter or murder, depending on the evidence.
Okay, good.
But here is the critical loophole. Prosecutors often struggle to prove beyond a reasonable doubt that the delay itself was the definitive cause of death separate from the initial blow.
Oh, I see.
Yeah. If the medical examiner cannot definitively testify that an earlier phone call would have guaranteed her survival,
Hmm?
the specific act of walking away, of leaving the victim to die, it falls into a legal gray area.
So they get away with the omission.
Exactly. The system routinely fails to punish the omission, the deliberate choice to do nothing.
That feels incredibly broken. I think anyone listening would agree that watching someone die to save your own skin should carry its own severe penalty.
You would think so, yeah.
So why is this such a massive legal hurdle? Why is fixing this loophole treated as some sort of constitutional crisis in the UK?
Well, because to fix it, you have to attack one of the most deeply entrenched, centuries-old principles of British common law,
Which is?
the concept of negative liberty.
Okay, we hear that term thrown around in political science, but how does negative liberty actually dictate criminal law?
So it is the foundational liberal philosophy that individuals should be free from state coercion. The entire architecture of British criminal law is built on the concept of actus reus, which means a guilty act.
So you actually have to do something.
Precisely. To be labeled a criminal, you almost always have to commit a positive action. You have to strike someone, steal something, break something.
Right.
The state's role is strictly prohibitive. They say, thou shalt not. They do not say thou must. Therefore, an omission, just failing to act, is generally not a crime, regardless of how morally repugnant that failure might be.
But wait, if we already make exceptions for lifeguards and parents, the precedent for forced action already exists?
It does, yes.
So why is extending that to a basic 999 call treated like a philosophical violation?
Because the existing exceptions are incredibly narrow and usually involve a voluntary assumption of duty. Let's map out those boundaries.
Sure.
The law recognizes you owe a duty to act if you have a special relationship, like a parent to a child. You chose to have that child, so you assumed the duty.
Or a contractual obligation, right? Like if you are hired as a carer for an elderly patient, or you are a lifeguard on duty at a beach, you are being compensated to act.
Exactly. You also have a duty if you voluntarily assume responsibility for someone who is vulnerable, or if you actually created the dangerous situation yourself.
Like starting a fire.
Right. Say you accidentally started a fire. You now have a legal duty to report it. Finally, there are strict statutory duties, like the requirement under the Road Traffic Act to report a collision.
Okay, let me test the boundaries of this with an analogy. Let's look at the current law like a swimming pool.
Okay, I like this.
If I am walking past a public pool, and I am not the hired lifeguard, and I'm not the parent of the child currently struggling in the deep end, I can legally stand right there on the edge of the water.
Yes, you can.
I can literally watch that person drown. And even if there is a life ring sitting right next to my foot, I have absolutely no legal obligation to kick it into the water.
It is a brutal visualization,
Yeah.
but your legal analysis is entirely accurate. Unless you push that person into the pool, or you are their legal guardian, the state cannot compel you to kick that life ring. The British legal system goes to extraordinary lengths to separate private, individual morality from public, enforceable law. You are legally permitted to be a terrible neighbor.
Knowing those incredibly strict historical boundaries, how are the architects of Danielle's law attempting to rewrite the rulebook? What are the actual mechanics of the proposed legislation?
They are proposing the introduction of a generalized legal duty to assist any person in immediate danger. They want to completely shatter the idea that duty only applies to parents and lifeguards.
That is a massive shift.
Huge. According to Edwin Duggan's analysis of the draft proposals, Danielle's law would introduce 3 distinct new criminal offenses.
Okay, let's hear them. First, it would become a criminal offense to knowingly abandon a person who is unconscious or gravely injured.
Right.
Second, it would be a crime to fail to call emergency services when someone is in clear immediate peril. And third, it would be a crime to deliberately withhold assistance following an act of violence or harm.
And that third provision is surgically targeted at the domestic abuse loophole we discussed with Danielle Haggerty's case.
Oh, I see.
It provides prosecutors with a specific tool to charge the perpetrator for the delay, regardless of whether the initial blow can be definitively proven as the sole cause of death.
Here's where it gets really interesting, because this isn't just closing a domestic abuse loophole.
No, it's much bigger.
This is shifting the entire UK from a framework of negative liberty freedom from state interference to a system of positive responsibility. You suddenly have a legally binding duty to your community. It changes the definition of citizenship.
It really does.
Yeah.
It asserts that you are criminally liable not just for the harm you inflict, but for the salvation you withhold.
Wow.
Now, While British legal purists view this as a radical, almost alien concept, if you look across the English Channel, it isn't radical in the slightest.
Yeah, the sources highlight that the UK is a major outlier here. Much of Europe already operates this way.
Heavily so. Adopting Danielle's law would merely align the UK with established duty to rescue frameworks found in Germany, Belgium, the Netherlands, and Switzerland.
So they already do this.
Yeah. Germany's criminal code, for example, explicitly mandates assistance in emergencies unless it puts the bystander in significant danger.
The sources focus heavily on France, too. They have a well-known legal principle called non-assistance à personne en danger, failure to assist a person in danger. It was instituted back in the 1940s.
That's right.
But how does that actually play out in practice? Do the French just arrest everyone who freezes during a crisis?
No, and that is the crucial context here. In systems governed by civil law, like France, communitarian jurisprudence takes precedence.
Communitarian meaning community focused.
Exactly. Society functions on the premise that citizens owe a baseline level of mutual aid to one another. The law is used less as a constant punitive cudgel and more as a powerful cultural deterrent.
It sets the tone.
Right. It sets a societal norm: you do not walk away from a dying person. When people are prosecuted, it is usually for egregious, deliberate acts of ignoring suffering, much like the domestic abuse scenarios Danielle's law seeks to address.
But introducing that communitarian mindset into a fiercely individualistic British system creates a massive friction point.
Absolutely.
And this is exactly where Edwin Duggan's perspective becomes so vital. He is a dedicated human rights advocate. His entire career, including his book Breaking the Chain, is built on protecting individuals from state overreach.
Yes, he's a staunch defender of civil liberties.
He actively campaigns to keep young people out of the criminal justice system. So when he was approached to support a law that actually expands the criminal code, he admitted he faced a profound ethical dilemma.
And you can completely understand his hesitation.
Wow, for sure.
He is weighing two massive competing priorities. On one side, you have the tragic reality of Danielle Haggerty's death and the undeniable moral imperative to prevent perpetrators from exploiting the system to hide their violence. Yep. On the other side, you have the genuine danger of compelled action.
Right. Because the moment you allow the state to enforce morality via the threat of prison, you are eroding personal autonomy.
This raises an important question. How do we practically define immediate danger or reasonable steps in the chaotic, terrifying reality of a real-world emergency?
It's so messy in real life.
Exactly. The fear from civil liberties groups is that expanding criminal liability for omissions introduces a terrifying level of subjectivity into the justice system. We are asking ordinary, untrained, panicked citizens to make split-second assessments in incredibly high-stress environments.
We watch too many movies where the hero springs into action. In reality, neuroscience tells us that most people experience an amygdala hijack during a crisis. They freeze.
Exactly. The human trauma response is unpredictable. What happens when a citizen simply misjudges the severity of a situation?
Or they just panic.
Right.
Yeah.
What if they witness a brutal assault and their biological trauma response forces them to freeze in terror? What if they have an active panic attack and drop their phone?
That's a very real possibility.
The danger of Danielle's law, if drafted poorly, is overcriminalization. We risk punishing human fallibility. We risk throwing a terrified bystander in prison simply because they didn't have the psychological fortitude to intervene.
The sources also detail a broader philosophical fear that Duggan wrestled with, the slippery slope argument.
A classic.
Yeah, if society concedes that the state can force you to act in an emergency today, what stops that mandate from creeping outward tomorrow?
It is the concern of any constitutional scholar. Once the precedent of compelled action is established, the boundaries can easily be stretched by future parliaments.
Like, if the state can force you to call the police, could they eventually require you to physically intervene in a violent attack?
Which would be disastrous.
Right. Could the duty extend to non-emergency situations? For instance, could it eventually become a crime to fail to report suspicious behavior in your neighborhood?
That's the fear.
You start inching toward a surveillance state mentality where every citizen is legally mandated to be an informant or a neighborhood watchdog.
Now, while those extreme dystopian outcomes are emphatically not written into the text of Danielle's law, they perfectly illustrate the philosophical tension.
A push and pull.
Yes. It is the friction between preserving individual liberty, the right to be left alone, and enforcing communal safety.
So, given these intense, highly valid fears, the fear of punishing a bystander who is just biologically frozen, and the fear of unchecked state overreach. How does the proposed legislation attempt to thread the needle?
It's a delicate balance.
How do you catch the malicious abuser without catching the panicked witness?
Well, the architects of the law and advocates like Duggan recognize that the law is useless if it creates collateral damage.
Makes sense.
Therefore, Danielle's law relies on incredibly specific, robust legal safeguards. The entire mechanism of the law is designed to isolate deliberate inaction from accidental failure.
Let's look at how those safeguards actually function in a courtroom, because that is where this matters. First, the law dictates that you are only required to take reasonable steps.
Keyword, reasonable.
Right. And in almost every conceivable scenario, reasonable begins and ends with dialing 999. There is absolutely no legal obligation to physically intervene.
Not at all.
You do not have to tackle an attacker. You do not have to perform CTR if you aren't trained. And you do not have to run into a burning building.
Furthermore, the law explicitly removes liability if the bystander reasonably believes they are unsafe.
Okay, that's important.
Yes, if making the phone call draws the attention of a violent attacker toward you, you are legally protected in your choice to stay silent and hide.
And crucially, the law protects against the panic response. There is no punishment for honest mistakes. If you misread the situation or if you freeze out of pure fear, you are immune from prosecution.
What's fascinating here is how the prosecution would actually have to prove this in court.
Yeah, how do they do that?
The law is laser-focused on deliberate, knowing abandonment. To secure a conviction, a prosecutor must prove mens rea parity, a guilty mind.
A guilty mind.
Right. They have to prove that the individual fully understood the gravity of the peril, knew they could safely assist by making a phone call, and actively, maliciously chose to do nothing.
But how do you prove that someone deliberately did nothing rather than just panicked? It seems hard to prove what's in someone's head.
In the modern era, it often comes down to digital forensics and behavioral timelines.
Oh, of course.
Yeah. If an abuser claims they panicked, but police pull their phone records and see that during the hour the victim was bleeding out, the abuser was texting friends, scrolling social media, or making a cup of tea.
The panic defense is gone.
The panic defense evaporates. The digital footprint proves the cognitive awareness and the deliberate choice to abandon the victim. The law targets willful neglect, not human imperfection.
So what does this all mean? Where did Edwin Duggan ultimately land after dragging this proposal through his own intense ethical stress test?
Well, after heavily scrutinizing the safeguards and weighing the loss of abstract negative liberty against the very real, tangible potential to save lives, Duggan concluded that the shift is not only justified, but essential.
He notes that the debate was never really about whether helping someone is morally right. I mean, we all know it is.
Obviously.
The debate was about whether the state should enforce that morality. Duggan's final stance is that in certain highly specific life or death circumstances, the protection of life simply supersedes the individual's right to choose inaction.
And he recognizes that implementing Danielle's law requires a profound recalibration of the relationship between the British citizen and the state.
It's a big change.
It is. But his argument is that a modern legal system must evolve to recognize modern vulnerabilities. With careful drafting, the law can target the abusers who weaponize inaction while fully protecting the innocent bystander who simply panics.
His endorsement carries immense weight precisely because of his background. When a human rights advocate, someone nominated for the True Crime Awards for his work preventing youth violence, someone who actively lobbies for a dedicated minister for knife crime prevention, says we need to give the state more power to prosecute people, listen.
They absolutely do.
He isn't looking to lock up innocent people. He is looking to close a fatal blind spot in the justice system.
It is a sobering acknowledgement that the tradition of negative liberty, while historically important, has allowed a culture of fatal apathy to take root in certain dark corners of society.
If Danielle's law is enacted, it represents a staggering paradigm shift for the United Kingdom. It fundamentally rewrites the social contract.
Completely.
It moves a nation from a baseline expectation of just don't actively cause harm to a legally enforceable standard of you must take minimal, safe steps to preserve the life of your neighbor.
It formally codifies compassion into law.
Which returns us to that dark street we imagined at the very beginning of this deep dive. You witness the emergency. You have your phone. Under Danielle's law, the state intervenes in your personal autonomy and says, you must make the call.
You have to.
And that leaves us with a lingering, slightly uncomfortable question for you to ponder today.
A question that pushes far beyond the boundaries of emergency response.
Exactly. If society collectively decides that the state can compel you, under threat of criminal charges, to make a phone call to save a stranger's life, where is the ultimate permanent boundary between being a morally good neighbor and being a legally compliant citizen? As our legal structures evolve to mandate community care, what other moral obligations, things we currently consider just doing the right thing, might eventually become strict legal requirements in the future?